No. Yes, yes, yes. Mob-handed yesterday. Right. Okay. So, well, after that marathon session on sentencing yesterday, did you want to say something about that now, Catherine, or just kind of flag it up a bit?
But I think it's something that we may revisit, because I don't know if you can get a couple of brands, and I still think that might speak into a question, because there have been a couple of really high profile cases. So yesterday's press reported that someone who works at the law offices was jailed for drink driving, and so I think you might well have a little question on paper saying about the appointment is due in the middle of a court investigation, that he's also being arrested for drink driving. His reason was, what's your advice? So I think we should be familiar with our guidelines. And I might just have a look at some of the materials that previous years have used to make sure we've got all the guidelines. What was that?
Well, we had it was known, but then when we were having a discussion about it yesterday, Advocate Thompson had it down as Turner.
I don't think that's the same place. Okay, I'll make a note.
But I have got this that I took from the office.
Okay, so that's new.
It's not on Guernsey Legal Resources.
No, I think we just need to put some more out.
Yeah, okay. Yeah. Right, okay. So, let me see. What does that say? Yes. Sort of thing that we need.
The sort of thing that pseudoephedrine is actually the stuff that's in cold remedies. That's why they take it apart and use it when they manufacture.
Can you actually get entered into a database every time?
Yeah. Where do you do that?
If you find that, they take your name and address from and put it into a database.
Yeah.
No, in the United States, because they have all these guys.
Well, I'm just good.
Sure, you need a lawyer.
Well, we had a discussion about trade.
Yeah.
Yeah, the first time I was
well, that might be. I think Gemma did come up with a reference yesterday. I think 2002, which I think it's abolished. Gemma, did you were telling us yesterday you managed to find something about Borstal training being abolished in 2002?
Yes, the criminal evidence just simply said that whenever a previous reference to Borstal training, it was to be replaced as youth detention under the youth detention law. But it didn't make sense in that context.
No, because it already said youth detention. Yes.
Yeah.
So it probably needs a consequential amendment without the
It's not being picked up.
to put the reference. Fantastic.
Well, it happens.
A bit of ad hoc research.
Very impressive.
Good.
Right. Okay. So I literally have no idea how long this is going to take. But I guarantee we will stop by 4 o'clock at the latest. Yes. Obviously, the tide's coming back in. I don't know. No. All right. Yeah. That's all right, isn't it? Get some lights up. Yeah. Do a bit of sea kayaking, night sea kayaking. I've seen them on BBC. Right. Okay. So, chapter 6. I'm not saying that we need to kind of dwell on this, but in the light of conversations that we had on previous weekends, I began as I was putting these slides together to think that it might be helpful just to have a kind of shopping list of the things that were in the chapter. I haven't done it with the cases particularly, but I have tried to do it with any pieces of legislation of whatever description, so that you've got a kind of coherent place to find everything. So, let's move on. So, generally, I have to say these don't necessarily follow directly what I'm going to be talking about, but looking at the start of chapter 6, then generally, as you can see, our primary court for juvenile crime is the juvenile court, which is not to say that the children cannot appear in what, for these purposes, we might have to just generically refer to as adult courts. But generally, of course, they'll be doing that when there's an adult involved in the proceedings, not exclusively, but yeah. So they've got their own particular forum. And of course, there's another forum that has as its primary kind of constituency children, which is the, I'm going to get this wrong, aren't I? Children, Youth and Community Tribunal, CYCT. Yeah, yes, works to that effect. Okay, so, however, the juvenile court, as it says there, is a particular formation of the magistrates' court, so there'll be a judge of the magistrates' court sitting alone. So from that point of view, it will look very much like the regular adult magistrates' court. So what is a child? Very important to know that. So under the age of 18, so that's when the jurisdiction of the juvenile court stops and the adult court kicks in. As you can see, age of criminal responsibility in Guernsey is 12. Yeah. Now, that's, I suppose, where it's marginally relevant to talk about what's on the slide then, because we have got this case X against the law officers from 2013, which just kind of flagged that up and thought about the age for criminal responsibility in connection with Doli Incapax, which if you are older than you all seem to be, you'll remember from practice, certainly I remember from practice, as an additional requirement. The prosecution had to prove that what our juvenile accused had done was, to their knowledge, wrong and seriously wrong. So, as well as the straightforward actus reus mens rea elements of the offence, there was this kind of additional requirement of awareness, and that was criticised from time to time, not least because it meant that kids that were, quote, dragged up in the gutter and hadn't been taught the difference between right and wrong, the prosecution tended to struggle, at least theoretically, to rebut the presumption of Doli Incapax. They were incapable of forming the requisite knowledge, whereas those that had been better brought up and had just gone off the rails, it was relatively easy to persuade the court that they certainly knew the difference between right and wrong, and that what they'd done was seriously wrong and they shouldn't have done it. So obviously the law was penalising the wrong group of children, so it had to be changed. And there you go. So as you can see, paragraph 18 from the X case, X was of course a juvenile, it almost goes without saying. Position in Guernsey is best being described as unsettled, but yes, on the review of all of the material, which I've saved you from there, satisfied the doctrine has not been clearly incorporated into Guernsey law at any time, the end. So that's just really for the sake of clarification as much as anything else. Okay, so what is it that the juvenile court can do? That's picked up in 6.3. So as you can see, commit child defendants for trial to the Royal Court, either if they're charged with indictable only offence, which we remember from previous meetings is the, what is it, THRRPP, sextet. Yes? Good, we'll leave that there then. Yes. Yes, excellent. Or an offence that may be tried in indictment, and decisions being made to do so. And of course, that decision, just like with an adult defendant, could be made by the prosecution, could be made by the defendant. I think the defence has the right of election here, don't they? Even though they're a juvenile. Yeah. Yeah. Or of course, the judge in the juvenile court could decline jurisdiction, therefore commit for trial. On the other hand, of course, and I'm assuming this is kind of the usual way of proceeding, have a summary trial, and if convicted, then crack on the sentence. Hear any breach proceedings regarding child offenders that have been sentenced to something that they could breach, like community service or suspended sentence, and then deal with them if breach is actually established. And as it says, sentence or otherwise deal with child offenders who've been remitted to the juvenile court for that purpose, which I'm assuming would normally be by, I don't know, the royal court. I guess that's probably the state of affairs. So, what else do we need to think about? Oh, all right, yeah. So there are, I suppose it's worth pointing out, there are these two major laws that you'll find referred to again and again within this chapter. The first one being, I mean, they're both 2008. The first one being the Criminal Justice, Children and Juvenile Court Reform, Bailey v Guernsey Law, 2008. And the other one, the much more attractively short Children brackets Guernsey and Alderney Law of 2008. You can see from the Children, Guernsey and Alderney Law, we've got findings on issues or matters referred by the Children's Convener under that law, section 67, or appeals from the CYCT. And lastly, applications for secure accommodation order, or a community parenting order, or emergency child protection order, or something called a section 17 order. You can see that's explored a bit more in the footnote 597. So I think it's fair to say that the juvenile court here, a little bit like the youth court in England and Wales, whilst its main function is, or it sits within the criminal justice system, it also kind of begins to shade a little bit into broader kind of community and social based systems through, for example, its contact with the CYCT. So that kind of gets us on to thinking about the CYCT. So 6.5, then you can see radical changes as far as matters relating to children in Guernsey and Alderney are concerned, and principal purpose to make sure that the law is reformed so suitable provision is made to protect children from harm, promote their proper health, welfare and development. And again, that's relatively standard. Maybe the wording changes slightly, but it's relatively standard. I think probably in most legal systems when it comes to dealing with the younger age bracket of defendants, things like welfare, deterring them from getting involved in a life of crime, or promoting their re-education, reform, rehabilitation, that sort of thing. So you find very similar aspirations or objectives in the law of England and Wales as well, going all the way back certainly to 1933 in the Children and Young Persons Act, saying that the principal aim of the justice system is the welfare of the child, that type of thing.
The convenience system is based on Scottish law. It can be used for the stuff to look at that. But it is a bit of a hybrid. But that's the real basis for it.
And am I right in thinking that the convener is an experienced Scottish lawyer? Yes. Yes. Yeah. Okay. So, moving on maybe then to the system, that system itself. We can see at 6.8 we have a children's convener appointed by the board identified there, and you can see the criteria for appointment. It is a public office, and therefore, as it says, functions have to be discharged fairly, impartially, and independently. The tribunal, somewhat conversely, has its membership appointed by the Royal Court, not by that board. And you can see that there are certain people who are not eligible for appointment, and that would include, as it says, advocates and lawyers employed by the states, anyone who's under 21 or over 70. Again, in terms of requirements for appointment, you can see that members do not need formal qualification, and you can see how the rest of that plays out there. And then there's a kind of separate office holder who is the president of the tribunal, and who will be appointed from the broader membership there. So from our point of view, we need to think about children being referred to the convener, and as you can see, any child who may be in need of compulsory intervention should be referred to the convener, with most referrals coming from the police or the Committee for Health and Social Care. And there is a two-part test which is set out 6:11 through to 6:13. So 6:11, is there anybody that's willing and able to take on parental responsibility in an appropriate and suitable manner? And if the answer is yes, presumably we get off the bus at that point, and that's what happens. But if the answer is no, then we move on to the second part, and the question is one of those 7 criteria satisfied on a balance of probabilities? Yeah. And you can see, for example, small 6, child is age 12 or more, so they have attained the age of minimum criminal responsibility, committed a crime, or what would have been a crime if the child had the necessary capacity. Now that's what it actually says, but given the slide on early incapax, it's a moot point as to what's actually intended as far as that's concerned.
I mean, that may be to do with the child learning difficulties.
Could be, yeah. Yeah. So yes.
He's not chronological. He's not.
No.
Chronological.
Yeah. Okay. So as you can see, then 6.14, if compulsory intervention has arisen and the relevant person or an appropriate person believes that it is necessary or may be necessary in order to ensure the child's adequate care, protection, guidance, or control, they can refer that matter to the convener, and there's a positive duty in certain circumstances for certain people to make a reference to the convener, and that would include where the child is to be detained in secure accommodation or youth detention, detained by a police officer or customs officer, or made the subject of an emergency child protection order. It's a compulsory notification. And from our perspective, sitting within the criminal justice system, we're looking at a decision being taken by a designated officer, and you can see the description of that individual at 6.15. The other point, I think I've put it, well, it's in bold and underlined, so it's not to be overlooked. And I think the reason for that, which stylistically is not something that I've gone in for very much in the study guide, is because whoever the adjunct was that reviewed this chapter very much wanted it to be presented in that way, because she, I think it was a she, felt that was of crucial importance. So that decision, or that review, if you like, about the sufficiency of evidence in order to obtain a possible conviction, being a realistic prospect, has to be made before the decision can be taken for the child to be charged. So as it says, excuse me, that report should also go to HM Procura. Did I get the emphasis in the right place there? Good. I've been working on that. So HM Procura, I'm going to slip back into something unacceptable, no doubt. As it says, if it's thought that there's a public interest in a prosecution, and note, traffic offences, it's obligatory to cross-report or co-report those to HM Procura, and you can see that's a joint referral. Yes, Julia?
So the decision is really based on the prospect, not on the second part of prosecution, and whether there is a public interest, because they should only proceed according to this guidelines if it's true.
No, well, I agree with you as far as the test for actually making a decision on charging is concerned, but I think the point there is that obviously you would say that the evidential sufficiency part of the prosecutor's code would require you to be thinking about realistic prospect, enough evidence for a realistic prospect of conviction as the first step in determining whether there should be a charge or not. But I think what this is saying is, like, once you've got to that, once you've satisfied step 1 of that charging process, then don't go on, or even whilst you're going on through step 2, before you get to the end of that and make a decision, you have to make the referral.
And so, for example, in family matters, an ordinary by the tribunal trumps the court, which actually was probably not what was intended. And I think that may be why the person who edited this part of the guide was just making the point that the convener holds perhaps unexpected and extraordinary power in this situation. And so the referral to the convener is really a first thing, because saying exclusively, but extensively determines what happens next in which path. But
Okay, so as you can see, where it's not a mandatory referral, so it's not a traffic offence, where that decision is being made as to whether to make the reference to the procurator as well as to the convener. You've got a list of relevant factors there. I don't think there's anything particularly surprising. Nature and gravity of the offence that's involved, whether the child is a persistent offender, their age, criminal record, if any, and their response to any previous sentence or order, and obviously anything else that the court thinks, sorry, not the court, the person making the decision thinks is relevant. In terms of persistent offender, I haven't found anything that unpacks that at all. That is a phrase or a concept that occurs in youth court work in England and Wales, specifically in the context of a sentence of detention for a child aged between 12 and 14. If they're a persistent offender, then they are at least prima facie eligible for a custodial sentence. But again, the legislation there doesn't define persistent offender either. There are kind of secondary sources and a bit of case law that suggests that probably a minimum of 3 offences would be necessary to consider a child a persistent offender, but that they could be maybe 3 offences that were before the court at the same time, but maybe committed on separate occasions or against separate victims, for example. So maybe just like a first appearance or single appearance, but if there are 3 offences, that might be enough to justify identifying the individual as a persistent offender. Whether the same approach would be adopted here, I haven't seen anything to either to suggest either way, whether it's the same, similar, or something completely different. 6.17 then, once a matter has been referred to the convener, there'll be, as it says, an initial investigation, and the convener will seek information from any current agency that's involved. So I guess that could be educational, that could be kind of welfare, social welfare, that type of thing. It might be that there are kind of healthcare agencies involved, so there might be psychological reports or assessments, that type of thing. But the net will be cast wide, I think, is the point there. And it may be that at the end of all of that, the convener decides that there's nothing further to be done, no further action needed. So that will be that. Alternatively, we could go for informal advice and guidance, and as it says, there'll be reference to local agencies, but with no compulsion involved. So this literally will be kind of nudging rather than anything more dramatic than that. But alternatively, if it is felt that it needs to be compulsory, otherwise the child or maybe family members would not engage with the process, then it's going to have to be a reference to the CYCT. So from our point of view, and I think it's becoming slightly repetitive here, but it says police are responsible for a significant proportion of referrals, and of course that would usually be in tandem with some allegation of criminal behaviour. It could be, like a street mugging, bit of criminal damage to someone's bicycle, taking next door's moped, that type of thing. So I think probably the rest of that, most of the rest of that paragraph is repeating, but just towards the end there, as you can see, it may be that once the matter is referred to the procurator, he or she may decide that the matter is best dealt with by the juvenile court rather than the tribunal. And if the matter does go to court and there's a finding of guilt made, then the court can bounce it in the direction of the CYCT if the court considers that to be the best course of action. So again, you can be brought into the criminal justice system, and you can have a disposal that pushes you back out of the criminal justice. I really see the tribunal as sitting alongside but outside of the criminal justice system. Yeah. Okay. What else do we need to think about that? Yeah.
think that must be the case, but
Hmm.
I might just check that specific point because it is, as I say, it's a real problem in the family division because the judges will sometimes decline to hear cases because it's running in the tribunal.
Mhm. Well, I mean, I
So I
suppose.
suppose the proctor ought to be able to come in criminal jurisdiction. But I think what might be helpful is put it in, I'll try and set out an example of what happens from the beginning. So a child is arrested because of a broken window and try and chart it through because we've got some examples in these.
Yeah, I think I don't know where it is now. No, I haven't done it, but I did say somewhere in here that there's a flow chart on the convener's website. Yeah, yeah, yeah. No, it's everything. It's got a bird's eye view. Yeah,
It's a funny one.
it always is when it involves children.
And actually, no involvement in it. So whilst it's there and then obviously he has to know how it works. Well, it's the tribunal is meant to be a lawyer-free zone. It's a matter of considerable controversy. Particularly in family matters where they actually do take people's children away without lawyers being present. It's for another lecture.
Yes, might be human rights issues there.
Although not in Scotland,
Well, there'll be independence soon, won't there? Right, so stop the controversy. Okay. Right, so anything else that we need to think about there? Oh, yes. Okay. All right, so I think that's probably all that I can say at the moment about the convener and tribunal system.
I think the other thing is just before the tribunal can sit, the convener will produce a statement of fact. On such and such a date, Johnny was found with a stone in his hands adjacent to the broken window of boots. It's a bit more complex than that, perhaps. If actually little Johnny doesn't accept the fact, then that matter gets exported to the juvenile court. The court sits like a normal court, determines the fact, but not the disposal, and then sends it back to the tribunal with the facts set out. The finding of fact is usually well, there may be a lawyer at that point, because that's a court matter. Legal aid is not generally available for the tribunal, it's very limited. So that's how it works in practice.
Okay, so moving on then to the heading of juvenile court at 626, you can see principal consideration is to prevent offending both in the short term, which may be through incapacitation, and the long term, which may be through rehabilitation or re-education there. And as you can see then, I think we've probably dealt with all the points in terms of functionality of the juvenile court at the start of the chapter. Procedurally then at 627, proceedings in the juvenile court are essentially conducted in private, which is not at all unusual for this type of work, with only the following people being allowed into court. And you've got a pretty standard list there. Note that, as is usual, witnesses will be allowed in only if there's a trial and they're actually in the act of giving evidence. So before they give their evidence, they won't be allowed in, and after they've given their evidence, they'll be kicked out again there. And I think we ought to know also that where 4th bullet point there, the child's advocate, certainly in my experience, not in Guernsey obviously, but in similar courts in England and Wales, you may have a case on the list and you may be thinking to yourself, well, I don't want to be out there with all of those people, so I'm going to retreat to the safety of the courtroom and sit in a seat that is reserved for people like me, where it's all nice and safe and I don't have to have difficult conversations, etc. But you won't be let in, because if it's not your case, then the court's going to say, well, sorry, why are you here? Would you kindly leave? So when it says the child's advocate is allowed in, it means specifically the advocate for the child whose case is currently being attended to by the court. So, if you're one of those people that likes to think, well, know your judge, spend some time in court, get a feel for the do's and the don'ts, the court's likes and dislikes, well, you're going to have to pick that up for yourself through actively appearing in the court in other cases. So just accrue it over time. You can't just sit there like you would normally do in a courtroom and observe what's going on, because you won't be allowed to come in. And once your case is finished, you'll be chucked out.
It's possible that it would be agreed to accompany with you.
Yes, I think that's
that would be
usual.
acceptable,
Yes.
but I agree with Rob that generally it's paid down to bonus if you can be.
Yes, and there was an example, which I don't think I've actually put onto a slide. There was an example of a child appearing in, I think it was the Royal Court, if memory serves me correct. Unfortunately, I can't remember the name of the case. It probably is in this chapter somewhere. But a child was appearing in the Royal Court, and the judge of the Royal Court ruled that the proceedings would be heard essentially in chambers or in private, just using the inherent jurisdiction of the court, so that it mirrored what would have happened in the juvenile court. So even in situations where you've got an adult court, which would normally be obeying the principle of justice being seen to be done, public access, that type of thing, if there's a juvenile appearing in it, then it's entirely possible, and indeed I would have thought quite likely, that the court would make a similar decision to the one that I can't remember the name of. I don't know, it might be. I'm sure it's in this chapter somewhere, anyway. All right, towards the end then, you can see of that list of people allowed in, anyone who the court satisfies as a genuine media person, which kind of gets us onto thinking about reporting restrictions, or gets me onto thinking about that anyway. So there is a slide picking up a case of Pressland, and you can see there that this is kind of, I guess, related. It's not specific as far as juveniles are concerned. You can see this was a rape allegation against an adult defendant, but the complainant was aged 15 at the time the offence was alleged to have been committed. And as far as I can work out from the judgment, it was around 17 at the time of the trial. As you can see, the court made an order there. So this would have been, again, an adult court. It's making an ad hoc order for these purposes, that the media weren't to basically report any information that was calculated or likely to lead to the identification of any juvenile involved in the proceedings. And in this particular instance, you can see the juveniles here were not the accused, they were the complainant and other witnesses, like friends of the complainant, that type of thing.
I think the only also put on that is that law's gone, isn't it?
I think that has.
And we've got the 2008 law, and there has been, there's a lot of discussion about reporting restrictions, because the 2008 law includes a restriction related to the children law.
Yeah.
And so you're almost then stuck only with your key case. And if the court does cover powers. So I think Resland is possibly just got to be
I'll check that.
careful about President Abdul.
Okay. Right. So, who else is going to be there? Well, the fifth bullet point said the child's parent or anybody that's got parental responsibilities. I guess that could be like a social worker. And you'll see there's a heading of parents at 6.29. So they will be required to attend, generally speaking, required to attend through the proceedings. And a refusal to do so can result in a warrant being issued to authorise the arrest of that individual and their production before the court. So there you go. As it says, if the child has already been through the system and is subject to community parenting order, then a representative of the committee must attend, which I think is the Health and Social Welfare Committee?
The community parenting is an order which transfers the care of the child into the care of the HSC, Health and Social Care.
Yes, 6.30, then the court can dispense with that if requiring parents' attendance would be unreasonable or attendance is not essential to the just hearing the case or presence would have a detrimental effect either on the proceedings or the child's welfare. So this might be where you perhaps think that you'd normally want either the father or mother to be present, but for whatever reason, maybe only one of them is available, but there's been a fundamental breakdown in the relationship between the child and that particular parent. It just wouldn't be productive for anybody, particularly the child, to require that particular adult to attend the court. But as we can see from 631, you could substitute in another family member, maybe grandparent or an older sibling, perhaps. So that's a possibility. Bail is something that we just need to think about. Obviously, we haven't looked at Chapter 3 on bail yet, so we'll come back and do that before we wrap up today. But as you can see, in general, this is a very general statement of principle. The laws that apply to adults on bail also apply to juveniles who go through the system. So the bail law of 2003 applies, but as it says, subject to Part 5 of the Criminal Justice Children and Juvenile Court Reform, Baby Wilfred Guernsey Law of 2008. So 6.33, I think, refers to a slight wrinkle because Part 5 of the CJCR law talks about defendants and applies to defendants who are defined as a child defendant or child offender under the age of 17, but the same law defines child as a person under the age of 18. I have to say, I don't understand the rationale behind that. I'm sure there is a logical reason somewhere, but I haven't tracked it down.
I think it's historical.
Yeah. So as you can see then, you've got a rather weird situation of 17-year-olds where Part 5 doesn't apply to them, and they're therefore subject to the adult bail system. Yeah, there we are. So police can remand a juvenile defendant, which is to say somebody under the age of 17, into custody, and that's in one of the following 4 situations or 4 ways of remanding into custody. So into the care of the committee, or in the care of that committee but placed in secure accommodation, or into police detention. And again, the adjunct wanted me to make clear that that includes customs and excise detention as well, or in the state's prison. Now, I would imagine that last one is a position of last resort.
Absolutely. I mean, the secure accommodation isn't very simple. That would be preferable. There's a secure accommodation unit, which is up on the site of the old, with the same. It's a locked unit. It's got like fences around it, but it is essentially not a bad living space, and children get placed there where they are putting themselves at risk. That's a different type of thing from this, but where you've got a child who's constantly running away, putting themselves at risk, associating with all people, that sort of thing. And that's another whole process for the community to apply for them to be put in there. But that's the unit that they use, and it's reasonably child-friendly, but it's not a great place. It's better than the prison. Police detention is awful here, so I'd be surprised if they keep them there for a minute.
No. Okay. So as you can see then, it's possible, 636, for the court to remand a juvenile into custody as well. But this time we are limited there. So obviously not police detention because it's moved out of the auspices of the police now, but the other 3 carrying on. So to remand a juvenile defendant either to the state prison or into secure accommodation, you've got to meet certain criteria. So you can see there the court would have to think about accommodation, what accommodation is available or required, and it might be, as Catherine says, you need somewhere with a big fence or a big wall around it to stop them leaving. It might be that you need some kind of specific accommodation for that individual to prevent them self-harming or doing something more serious. But also, as you can see then, what's the offence that they've either been charged with or convicted of? Is it a violent or sexual offence, or is it one that's punishable in the case of an adult with 10 or more years imprisonment? Or alternatively, have they got some track record of abusing the trust that is placed in any defendant when he or she is released on bail? So if they have a history of absconding and charged with or convicted of committing an imprisonable offence whilst in the care of the committee. For fairly obvious reasons, the duration of a remand in custody is limited, and that stands at 28 days, but it can be renewed under the supervision of the court. Warrants, pretty standard situation. If the child doesn't turn up, the court can issue a warrant. As it says there, it's in the court's power to back it for bail, but it might not be, and certainly I think the trend in England and Wales these days is certainly away from having warrants back for bail. They're seen as not really carrying the right message for defendants who have absconded. The fact that you've been arrested, but now we're setting you free all over again. I think it's felt that it brings home to them the necessity of surrendering to custody more plainly if they actually spend some time in custody before they're then produced back into court. Even if the court then released them on bail, it should be apparent to them that a decision had to be made which might have gone against them. Yeah. Okay, as far as trial is concerned then, fairly obvious the court has to do its work in plain and simple terms so that the child can follow. Obviously, they have an entitlement, not least under the ECHR, to understand and participate in the proceedings. So they will then be asked whether they plead guilty or not. And I'm assuming that is the plea that's taken from. And there was a reference earlier in this chapter to the court making a finding of guilt. Certainly that's something that would happen in the youth court in England and Wales. The court would say we make a finding of guilt, or little Fred has 3 findings of guilt recorded against him. They wouldn't be referring to convictions or we find you guilty, that type of thing. It's kind of semantic shifts to really, I guess, minimise the risk of little Fred feeling stigmatised and branded, in front of everybody as a convicted criminal. Although I guess some of them would actually prefer to be stigmatised as a convicted criminal because it builds up their rep. Yeah. So, works both ways, really. Yeah. Yes, like having your first tattoo. So, all right, but it's going to work exactly the same way as the summary trial in the magistrates' court would do so. If they plead not guilty, prosecution case, prosecution evidence, and it says that the child will be entitled to cross-examine. Of course, what that really means is that the child's advocate would normally be doing the cross-examining of prosecution witnesses. If the child is not, for some reason, legally represented, then the parent or guardian, whoever is there with parental responsibility, would usually be allowed and perhaps assisted in assisting the juvenile themselves to represent themselves and present their case effectively to the court.
Assesses the child's means. So unless the child has access to the trust fund, in which case the trust fund would pay for an advocate, the child is going to get legal aid. I think the court, even if there was some hinterland, the court would be saying this child needs to be represented. Because that's really not a fun situation for the court to have an unrepresented child.
Yeah. No, I mean, I think to be fair, you can see that really this section, there's lots of references in the footnotes to the 1990 rules, and I think that's just that the rules are there to cater for every possibility, really. Yes. Okay, so as you can see then, at the end of the trial, assuming that the juvenile is the subject of a finding of guilt, then there may be an address by the defence to the court. Court may require a report from a youth justice officer, bless you. And again, you'll see in the footnote there, the Youth Justice Service is effectively probation service for the under 18s, separate from the probation service. Again, a point that I was asked to emphasise by the adjunct who reviewed this chapter. So they're separate entities, although I guess going along parallel lines there. Yes. 642 is the Doley Incapax point that we've already looked at. Reporting restrictions, this might bring us more up to date, I don't know. Automatic restrictions when appearing in court, nothing to be reported that would enable anybody to identify any child in the proceedings. This is as far as the juvenile court is concerned. And you can see that it's an offence to publish prohibited material. And I think we thought, well, I mentioned briefly that case of the BBC News editor yesterday in a similar but different situation, reporting the name of a complainant. Well, I think she was a child at the time that she made the complaint, so very similar situation. Yes, 647 ad hoc reporting restrictions, which is where we pick up the case of Pressland, but as Catherine said, we probably just need to go and check exactly what the governing law would be as far as that's concerned. All right, appearing in adult courts then, 648. So as you can see, the regular magistrates court and the royal court, sitting in either capacity, but I'm going to assume normally sitting as a full court, may try a child defendant in certain circumstances, charged jointly with an adult, or the adult's charged at the same time with what we might loosely describe as a related or associated offence. So something that is ancillary to the offence allegedly committed by the child. That's what the provision says. My assumption when I read that was that surely it works the other way around as well, but that's not actually what the provision says. So, I mean, if a child defendant is supposedly aiding and abetting, well, I don't suppose they're necessarily counselling or procuring, but I don't know. So I'm not sure if it's a kind of one-way street there. It seems to. That's how it read, but I'm assuming that it's actually a two-way street, just in terms of establishing the factual connection between the two defendants. Or again, as you can see, an offence that arises from the same facts or are connected with those, as far as an offence alleged against a child defendant is concerned. So there could be a committal for trial, or committal proceedings anyway, against a child and an associated adult defendant. And if the court starts, this is kind of getting us on to 6.50 and that little run of paragraphs there, if the court starts to hear a case under the impression that the defendant is an adult, but learns in the course of those proceedings that in fact the defendant is under the age of 18, then they can just carry on if it seems appropriate to do that. They don't have to, but they can do. What? Mistakes? Mistakes about the age?
Well, yeah, I'm not aware. This is more likely in
Well, yeah, I mean, there was a case which attracted a bit of media attention about 4 weeks ago, just before Christmas. I can't remember where it was a school somewhere, I think, in the southeast of England, where, needless to say, some teenager had popped up on their Instagram account a photograph of someone and said, "What's this 30-year-old bloke doing in my maths class?" And that was, I think, someone that had claimed asylum, and there was an issue about how old. And I think it did turn out that he was, I think, in his 30s or certainly late 20s anyway. But no, this is obviously a problem. You had the situation when we still had the first or the second variation of the jungle at Calais, and Home Office or border agency officials were going over because there was that provision that Lord Dobbs had brought in about, like with the kind of kinder transport thing, about bringing children into the UK. And then we go over and checking, and apparently it was, you check teeth, like tree rings,
Yeah.
that type of thing. Yeah, I'm not quite sure how it works, but I'm sure it isn't like, I don't think you slice it. Why? It's not an invasive. It's not an, well, I think, yeah, I think it's not 100% accepted scientifically, but I think it as a kind of practical way, as I say, that isn't terribly invasive. And I'm not sure how else. In the absence of documentary evidence, you know, obviously you have the child, you have the living evidence there. Yeah. No, well, I mean, as I say, I don't know how else. I don't understand the science behind it. I don't know how it works, unless you can simply tell. You know, I know these are, you've lost all your milk teeth, so you must be at least 17. But I think I lost all my milk teeth by the time I was about 12, so I've not got asylum anyway. No.
Well, it is the right to go to. I mean, who knows if this gets people washing up, but I don't believe it's ever arisen. Obviously, they've got to have the powers.
Yes. So what else have we got? Yeah, so really that next run of sections is kind of just trotting all the way through all of that. You'll note at 653, any order or judgment that has already been made won't be invalidated by finding the person's age was incorrectly stated, unless, as it turns out, it wasn't lawful, given the person's true age, in which case it will be set aside and a lawful order would then be made. They'd have to
set aside,
yes.
Yeah.
In terms of, there's no mistake, but it just so happens that our child reaches the age of majority whilst the proceedings are still jogging along, then, as you can see, no longer deemed to be a child if his 18th birthday came around before a mode of trial hearing, assuming there was one, or alternatively before he entered his first time he entered a plea to the charge. So it says if he was still aged under 18 on either of those hearings, then the juvenile court will hang on to him and they'll pass any sentence that is juvenile appropriate at that point. But obviously, if he's reached his 18th birthday, then he'd be entitled to be transferred up to the adult system and proceeded against that way. Right, sentencing. As you can see, all of the relevant courts, in terms of adult courts, Magistrates Court, Royal Court, Court of Appeal, have the jurisdiction to pass sentence on a child defendant. They can, however, send the matter to the tribunal for the appropriate disposal to be considered there, or send the juvenile to the juvenile court for sentence there. Likewise, if a child is convicted by the juvenile court itself or by the Court of Alderney, then those two courts can pass sentence or send the juvenile to the tribunal. And if a child is convicted on SARC, then the Court of the Seneschal may pass sentence on him. But I don't think that that court can make a remittal to the tribunal. I think that's right. I haven't found a power for them to do that.
They've only just accepted children law.
Right.
So we will have to check that.
All right, well, 656 deals with quite an important point then. So if there's been either a guilty plea or finding of guilt after a trial and the matter is remitted to the tribunal, that will not constitute a conviction. Yeah. Having said that, if the juvenile then comes back up in front of a designated officer a bit later on in their career, and the designated officer is considering whether to make a reference to the convener, or a reference, I guess, more likely to HM Procureur, then they can take that matter, we'll call it a quasi-conviction, into account. So obviously that's going to stay on the juvenile's record. What its status would be is, I suppose, open to question. 657, no general principle that a juvenile offender should necessarily receive a shorter or lighter sentence, so a different type of sentence than an adult would who was convicted of the same offence. So yeah, you've got this case of I'm going to call it Degaris. Is that how it's pronounced? Degari. Okay, all right. Pardon one. So, are you cold? Oh. Is it, have we not interfered with the heating? Have you turned it on? No. We'll have a whip round. Yeah, or burn one of the tables. Yes. All right. So it's an interesting paragraph. The court is mindful that the young person's culpability is less than that of an adult because they lack the experience and haven't developed their capacity to realise the full implications of what they've been up to. So it's normally appropriate for the court to pass a shorter sentence than it would if it was an adult. But there is no general principle that a young person must necessarily receive a shorter sentence. The court may legitimately have regard to deterrence as an objective or any other factors that would outweigh any allowance to be made for defendant's youth. So I guess it's there on the list of things for the court to think about, but it's not going to be some automatic reduction because you happen to be a 15-year-old as opposed to a 20-year-old or maybe a 25-year-old. Yes, all right, let's have a quick look at the next one. Our old friend, Mr. Hammond, I'm going to call him Hamill.
Yes, that's right.
Good, thank God. Resurfaces here. Remember the famous Mill Street assault, yes, of yesterday. So as you can see there, his advocate Morris, emphasised his comparative youthfulness when compared with the others. I think there were 3 or 4 others, all of them I believe were female. And the Mill Street assault was an attack on a female. So yeah, 16 years old on the day of the assault. And you can see in paragraph 26 there, the court agreed with the advocate's submission that the culpability of an offender is to be judged by reference to age on the date of the offence, notwithstanding that they may be of an older age by the time they come to be sentenced. I mean, you'd like to think there wouldn't be such a delay in the proceedings that made a significant difference. There we are. Culpability, of course, being one of the key considerations of any court when it comes to establishing the seriousness of the offence for sentencing purposes. Yeah. So it's always typically it's culpability on the one hand, and harm to the victim on the other, harm that was intended or happened to be occasioned, that type of thing. All right, sentences then. Yes, sentences. So obviously no imprisonment as such. I think it is possible, although I don't think I've actually dealt with it in here, possible for obviously a juvenile who happened to kill somebody and be convicted or have a finding of guilt as far as the homicide related offence was concerned, some form of detention for life. I think that's what it would normally be for a juvenile, detention for life, not life imprisonment, obviously. But these are kind of semantic distinctions that one would be making here. As a juvenile, they wouldn't be sent to an adult prison in any event. They'd always be in age-appropriate accommodation.
And just bear in mind, and so any prisoner who gets a really long sentence is likely to be fit.
Yeah, although obviously that's going to have consequences in terms of continuing family contact, and that's going to be quite significant for a child.
Massive cost. I'm not familiar with. There are very few murders. When we have the manslaughter, think one of those was, yes, one of those was a juvenile sentence from my client who wasn't a juvenile, was 5 years. I think hers was slightly less, but she served that. And as you say, that would be a real, it's a real problem anyway.
Yeah. Okay. So, youth detention then, as you can see, if the offender is aged 14 to 20 inclusive, may be sentenced to youth detention. So again, I guess that's something for us to bear in mind, that in terms of the juvenile court having jurisdiction up to the 18th birthday, the sentence of youth detention is kind of shading across from the kind of upper age range of the juvenile court into the very lowest age range appearing in the adult courts as well. So it'd be perfectly commonplace, one would imagine, for a 19-year-old, 18 or 19-year-old to be sentenced to youth detention by the magistrates court. So as you can see then, the requirement would be that it's an imprisonable offence in the case of an adult offender, and the court considers that custodial sentence is the only appropriate method of dealing with the offender, which of course the usual custody threshold there. Maximum term of youth detention is the same as an adult might receive by way of imprisonment. So there's no kind of artificial cut-off or ceiling just because it's a juvenile that's getting the custodial sentence there. Interestingly, it may be suspended, just like imprisonment for an adult defendant. As you can see, if the suspended sentence kind of takes us across the juvenile's 21st birthday, then if it does get activated, they won't be sent to anywhere that would be holding them for youth detention purposes. They'll be sent to the regular adult part of the state's prison. All right, as it says there, at 662, in addition to stating in open court custodial sentence is the only appropriate method of dealing with the offender, the court must also find offender unable or unwilling to respond to non-custodial penalties, and that could be because they were sentenced to a non-custodial penalty and they're back for breach proceedings, as far as that's concerned. Yes, it's already been tried and it hasn't worked. Or as you see, custodial sentence is necessary for public protection or prevention of crime, insofar as those two are different things. Or the offence is so serious that you can't justify a non-custodial sentence. Court has to take account of any information, which I think probably means that it has to seek to obtain that information before imposing a sentence of youth detention. As you can see, before passing a sentence 6 months or longer, it must consider any report on the offender, either one made by a probation officer. Yes.
It will always adjourn for a report. It's a fairly automatic process. The way the law is phrased doesn't really give you that sense, but that's the way it flows in real life.
Yeah, I mean, I think there is the provision, the corresponding provision in England and Wales would be that the court would have to obtain a report on the juvenile unless it was A, unnecessary to do that, and B, there was already one available that was reasonably
contemporary. They do a stand down.
Yeah.
So they just a stand down report where the court already has reports which is a little bit out of date, and they just adjourn for a bit and leave justice work or speak to the defendant and the family and the same thing happens. You can have a stand down report. You can also have a stand down report if the court doesn't think it needs a full report because it's thinking there's probably an alternative to custodial sentence which wants to check that that's available. Because it can't pass community service without being told by a probation officer or a youth justice worker that community service is available and that the person is suitable and that they've been told how to do it and what happens if they don't. So that's how it works in practice.
Yeah, okay. 664, youth detention can be consecutive or concurrent. exactly the same principles as would apply in the case of an adult. And as it says, if the offender is convicted of an offence that's punishable with youth detention and or is already serving a sentence of youth detention, the new sentence may be ordered to run consecutive to that. Yeah. Alternatively, if they're serving a sentence of youth detention convicted of an offence having reached the age of 21, then the court may impose a sentence of imprisonment to run consecutive to the term of youth detention. And presumably once they've reached the age of 21, then they'll have been transferred out of youth detention anyway into the adult part of the prison. Supervision, post-custody supervision, 665, placed under the supervision of a probation officer for a term of 3 months, or, as it says, the date that his sentence would have expired if he hadn't been granted remission on that sentence, whichever is the later of those two. 666, there can be requirements attached to a release on supervision, and non-compliance is itself a separate offence. So you can see that in 666. Extended sentences, I haven't said very much about that, but as you can see, I think we did mention it briefly yesterday when we were looking at sentencing for adults, but pretty much the same idea here. So if it's a sexual offence or a violent offence and is sentenced to 4 years or more, then will fall into the regime for an extended sentence. And what that will mean is that, as it says in 669, sentenced to the usual term, whatever that would be, of youth detention, that the offence merits, plus an extension period, which is the whole point about the extended sentence, and that lasts so long as the court feels that it's necessary to prevent further offending and ensure the juvenile's rehabilitation, and would be under licence. So has been released, but is under supervision at that point.
And so, that supervision would be
community service, nothing really to add to what we saw yesterday, but you can see there's a minimum age there of 14. So 12-year-olds, 13-year-olds don't qualify for community service. Compensation, courts can order compensation, but the good news is that if it's a 12 or 13-year-old, so at the bottom end of the age bracket, then the sum will be ordered to be paid by whoever's got parental responsibility, just to bring home to that individual that they have failed so far in carrying out that responsibility. As it says, if the offender is 14 or older, the court may make an order that the parent actually pays. As it says, 672 is getting a bit esoteric here about parents going on the run to avoid paying fines, but I suppose that's a possibility. I'm not really going to get into that. Attendance centre orders is our next sentence. I've put in there what I discovered. You can see we've got the redundant reference in 675 to Borstal training, so I'll probably take that out and replace it with a reference to youth detention. But Catherine, we said, I don't know if you would have picked that up now.
I will pick it up. There's the other reason, because if it's not known,
Yeah.
so that might be, but I mean, I think these things are very rare in practice. I don't actually think we've got to attend this, so I'll find out.
That's got on the run.
That's what you do with juveniles, but I'll find out. I suspect that the community service is the way.
Well, I mean, I have to say, attendance centre orders have never struck me as a particularly effective form of sentence. I mean, they were intended basically to occupy juveniles kind of Saturday afternoons, as far as I could ever make sense of it, to make sure they couldn't go off to a football match or, you know, smash up the playground or whatever it was they normally did on a Saturday afternoon. Had to undertake supervised activities. But,
that's why I think the community service will have replaced it right after I've been involved in a case where
okay, fines and costs, we've already kind of covered that. Supervision orders, Under 681, court may make a supervision order when dealing with the child offender. Somebody appointed by the court to advise and assist won't last for longer than 2 years and would, in any event, pass when the child reached the age of majority. If they reoffended whilst the supervision order was up and running, or failed to comply with it, perhaps by not keeping appointments with their supervisor could inform the court. That would be then investigated by the court, requiring the juvenile to come before it. And as it says at 683, supervisor should try to inform the child of the facts of the alleged breach prior to the court appearance, although, of course, if the breach is that they're not maintaining any contact with the supervisor, it might be impossible for the supervisor to give advance notice there. As you see at court, if the child doesn't admit the breach, then there'll have to be evidence heard in order to make a determination. But if they do admit the breach, or indeed the determination is found, then, as it says, there'll be arguments about how to dispose of it. So perhaps just to continue the supervision order running, no doubt with some stern words being said to the juvenile, but it can fine to kind of bring home to the juvenile and or their parent the necessity of complying with the supervision scheme, or revoke the order and re-sentence the child, or simply throw the towel in and revoke the order. Yeah, I mean, it doesn't seem very likely, but I guess it happens from time to time. And as you can see, either the child offender or the supervisor can apply to the court that made the supervision order to vary it, revoke it, or revoke it and then re-sentence. These are the sorts of things that might happen by application, either where the supervisor perhaps feels that it's not necessary to have the order in place anymore, it's maybe been in place for a year, 18 months, something like that, and it's basically done its job, don't need to keep having meetings, and etc., etc. So well done, juvenile. Everything has worked the way that we dreamed that it would, so that's all good. Or alternatively, to go to the other end of the spectrum, your life has gone so horribly wrong and you've got all sorts of other sentences hanging over you now that it's meaningless to have this supervision order nominally continuing in place, because I'm not schlepping over to the mainland to visit you on a wing of whichever young offenders institution you're currently being housed in. So we'll just cancel it then, shall we? Yeah, I mean, that's it. So we're either going to say it's done its job supremely well and ahead of schedule, so let's celebrate that fact by wrapping it up nice and early, and we can all feel good about that, or it's gone horribly wrong, it just hasn't worked at all, and the juvenile has continued their headlong plunge into the abyss, and the supervisor doesn't want to accompany them on that journey, which is to sever the ties, so one or the other. Okay, so that is it for juveniles. It is now 10:17. Shall we give ourselves a break till, I don't know, 25 past? Yeah. I'll stop recording. I'd like to sign up again.